Hello, today I'm super excited about this session, and I want to welcome you to our fourth New Works Composer sessions as part of the Digital Discovery Festival. My name is Paula, and I'm going to be your host today. I'm excited to present Andy Bart, who's been part of the National Sawdust family since inception. Andy today is going to discuss intellectual property, and I know as composers, it's something that's very much on our mind as the landscape is constantly shifting. So he's going to discuss intellectual property in music and how creative works are born into a legal structure that sets rules for the ownership and exploitation of those works. Understanding those rules and the practices and entities that result from those rules is essential to artists maintaining control of their works and intellectual property and the economic potential of those works. Today, Andy will start with the basics of intellectual property and the pillars in the in the music business industry. And then we'll move on to questions about digital rights, and then we'll have the winners of our New Works Commission asking questions as we always do. But before we start, a little bit more about Andy. Andy Bart is a trial lawyer with over 40 years of experience specializing in copyright and entertainment law, and he's been on the Billboard list of top music lawyers for over the past 5 years. He graduated from Columbia Law School in 1978 and became a partner at the law firm of Pryor Cashman in 1986, and has been with the firm of Jenner and Block since 2006. He has received numerous recognitions and awards from major legal ranking services and publications. He's been involved in assisting National Sawdust on legal issues for the last 4 years. He's helped our artists in residence on issues ranging from everything about the creation of new works to contracts to intellectual property and more. And we have been so grateful for his time and his energy. It is a pleasure to welcome him. Hello, Andy. Hi.
Thank you, Paula.
So nice to see you.
I'm going to apologize right. It's great to see you too. I'm getting all of these wonderful internet unstable messages, so we'll just hope for the best and keep on moving. But it's a pleasure seeing you again, and always great to be working with National Sawdust.
Thank you, Andy. Well, I know we're going to start off with a presentation. And so I'll let you to it, and then I'll come back on and ask you some questions that have been coming our way, and that I have as well about this kind of constantly shifting digital landscape. But I'll let you start with the pillars as you have them, and just really grateful to have you with us.
Great, thanks, Paula. So, as Paula said, I'm a trial lawyer, and that's my training. But since 1983, when I got my first music copyright case, which was an old Led Zeppelin music copyright infringement case brought by Willie Dixon, it tied me back into music, which is my great love anyway. So it's a pleasure to give you some of this background. I'm not the ultimate copyright guru. There are people that spend their entire professional careers looking at all the arcane corners of the copyright law, and I'm not one of them. But through litigating cases over decades, I certainly have the basics, and my firm, Jenner and Block, is involved in a lot of drafting of legislation and changes in the way that music is administered, and particularly in this digital age. So that should make for some good discussion about the changes. So let's start the slide presentation if we can. I set this up so that it will have the basic core elements of music, and the starting point for any of this on the first slide is separating the song from the sound recording, because under copyright law there are two separate copyrighted properties when you're dealing with music. There's the underlying composition, symbolized here by the sheet music with the staffs on the left, and a sound recording. I didn't pick Sam Smith as the choice. This was from a prior PowerPoint deck, but it serves the purpose. So there is a copyright for the musical composition, and musical compositions have been copywritten since the very beginning of the Copyright Act, going back to piano rolls and under the 1909 Act. Sound recordings were not. And sound recordings were not given federal copyright protection until 1972. They were protected by various state laws. And so a lot of states had common law copyright or unfair competition ways of protecting sound recordings. But starting in 1972, all sound recordings could receive federal copyright protection as well. And they are separate in pieces of intellectual property. And when you're looking at questions of copyright law involving music, the first step is making sure that you understand whether or not you're dealing with a composition or dealing with a sound recording. Next slide, please. Or should I do that? I guess I can do that. There we go. So this slide has one piece of the original slide, that we're ad-libbing off of the PowerPoint that was somehow converted into Google PowerPoint. I don't know the technical part of it, but the idea here was originally that it showed different ways in which compositions could be recorded. And they had CDs, a record, which you see here, a cassette tape, and then Spotify symbol for digital transmission. Let's see if I can move it on. No, if you could just take me to the next slide. So when you think about the music business, there are lots of people that are involved. And obviously it has to start with writing the composition because the sound recording is a performance of a composition. So we start with songwriters. The songwriter's work is then often controlled by music publishers who generate commercial exploitation of the songs. And then you move on to the recording of the work, and you have performers and producers and record companies and all of the entities that you see down on the left-hand column until you get to retailers. And at that point, you're starting to talk about how the finished product is being exploited. It's being sold through commercial retailers, not so much anymore. Back in my day, there probably was no greater treat than going down to J&R Records on Park Row and spending a few hours, at least for me, in the jazz store. But that is really only resides in my memory at this point. And so if you want to buy the remaining physical product, you pretty much have to go to a website like Amazon and buy a CD. Or they're available from other sources as well. But there is mostly now downloads and even more so streaming. And the whole evolution of this is fascinating and really perhaps a little bit beyond the scope of this story. But the real triggering event was the invention of the smartphone and the dissemination of the iPhone starting in about 2007, because there were streaming sites for decades. The ability to play music over a computer or over a web site has existed, but until people could take it with them, it never really got traction. And so what happened, and forgive me for, I told Paula I was going to wind up engaging in a bunch of digressions, so here's the first of them. So what happened starting in about 1997 was that CDs, which consist of digital music files, mostly MP3 files, that's just a format of digital files, were stripped and became available on the internet. And companies like MP3.com and Grokster and Napster and a variety of others made what was very heavily guarded, protected intellectual property available to everyone and for no cost. And that was the most radical revolution in music that you can imagine. The music world as it existed prior to 2000, maybe 98 or 99, was if you wanted music, you got it through an authorized dealer. That yes, people made bootleg records, but the amount of bootlegging and the amount of infringing product was relatively minimal. Once MP3 files were up there, the genie was let out of the bottle, and it was impossible to put it back. And the music industry went into free fall from 97 till the early 2010s. And what happened at that point was that the model of consumption of music changed from a possessory model, owning records, CDs, cassettes, etc., to an access model through streaming. And that provided a lifeline to the music industry. If you look at charts of music industry performance over the decades, over the years, there was a tremendous uptick when CDs were invented in the early 80s, and tremendous profit taking, and a lot of the hostility towards record companies came from their profit taking during those years. And whether it was through hubris or just karma, that whole house of cards collapsed in the late 90s. And now we're seeing the start of a new ecosystem over the last 7, 8, 9 years, where people are again paying for access to music, at least many people are, through streaming services. So that was just a background history story, but it provides some context for all of this. Performing rights organizations are what they sound like when music gets played to a public group. There are rights, public performance rights that go along with that, and the PROs, or public rights organizations, best known as BMI, ASCAP, CSAC, and others, monitor and collect that money. And then there are all the other secondary is pejorative to a sense, and I don't mean it that way, except for maybe the lawyers in the bottom right, are also involved in the music ecosystem. So let's move on to the next slide. So in terms of exploiting music, these are the three major ways, right? So the first is to, if you've created a song, a composition, and you want to make money from it, there are three basic ways that you make money. The first is people record that composition, and then the composer gets what's known as mechanical royalties from the printing of copies of that recording, or these days, Spotify and others pay digital mechanical royalties for the transmission of the recordings. The second is through publishing. That's really very minor these days. That's originally sheet music, but it's also licensing to film and TV, commercials, all of those things. And publishing companies will license the use of a commercial or of a composition in a commercial. And then, of course, live performances where the composition is played at places like National Sawdust, Carnegie Hall, and the Bart down the block, which also gets a performance license just to play the jukebox in the bar. So let's move on to the next slide. And this slide is just a pretty picture, really. Just saying again that it all starts with a song and giving examples of the underlying composition. So let's move on to the next slide. Okay, so when you're dealing with a composition, it starts with the songwriters, and then you have music publishers. So it's a place where I wanted to stop, because one of the first considerations for new composers or longtime composers when there's interest in their catalog is, do I get a publisher to work for me? Do I engage a publisher to exploit my works for me? And there are benefits to it, obviously. If you go to one of the majors, they have contacts all around the world, and they can field requests for licenses, they can police and collect royalties better. It's a much more efficient way of making sure that the work gets the maximum amount of exposure. But not surprisingly, it comes with a cost. And the cost is that the publishers take a big chunk of what the income is. And traditionally, what would happen is the publishing company would actually take the copyright in the song and leave the artist with an income stream. So the copyright in the composition would be owned by the major, or in this case, the new majors or indies, and the composer would get an income stream, but would not be the copyright owner. In recent years, there have been different types of deals. There have been administration deals where the composer will retain a copyright interest, and the publisher will simply get another, maybe a 50-50 split, and an income stream themselves. But there are lots of permutations of that, and I think that there's a lot, certainly for major artists, there's a lot of interest now in maintaining ownership of the copyright and only allowing the publisher to have more defined limited rights. But again, like everything else in our free market system, when you have economic power, when you have clout in the marketplace, it's much easier to negotiate these things. But there are lots of questions that go into that and lots of considerations that go into that as well. The PROs I mentioned before, they are the ones who issue public performance licenses and collect money whenever music is played in a public forum. Usually what that means is a venue gets a public performance license from each of the PROs that covers their entire catalog. So they're not licensing the use of a particular work for a contract, but in a concert, excuse me, but what they're doing is they're licensing their entire catalog. So whatever happens to get played at a venue that night, it's licensed if you get licenses from the various PROs. This is more relevant to National Sawdust than it is to a composer, but that's the way it works with public performance money. The Harry Fox agency is typically engaged in mechanical royalties. So when a composition is being recorded, they get the license often from the Harry Fox organization, agency, and Harry Fox collects the money. The MLC is going to be involved. That's a new entity that's been created under the Music Modernization Act, which just passed last year, and will be created to monitor and to collect digital mechanical royalties. So that's a new player in the publishing world. Can we move to the next slide, please? Okay, so what does a music publisher do? I gave a little bit of this a while before. Sometimes, and certainly back in the old days of Tin Pan Alley and the rest, they would actually find and discover songwriters, and many of the great songwriters from the 40s, 50s, and 60s were writers for publishing companies and were under contract to write for them. That really doesn't happen nearly as often as it did decades ago. Being businesses, they often buy each other's song catalogs with the idea that the bigger they are, the more resources they're going to have to be able to license and collect money. There are professional supports, there are legal tutorials, there are professional counselors, there's a lot of service and administration that the publishers can provide to songwriters. Of course, all of that comes with a cost, and that cost is the publisher's share. So licensing songs is a big thing. The mechanical licensing we talked about before. Normally, the composer of a song has the right to control the first recording that's made of that composition. But once it's been recorded by one party, anyone in the world can make a cover version of that song. And that is done through either what's called a compulsory or mechanical license that's issued, and the composer is paid on a per record or per copy basis. As I said, typically accounted for through the Harry Fox agency. Performance money we talked about before. Sync, which rears its ugly head in connection with today's streaming issues, is typically the synchronization of music with a visual image. And so typically, if you go back before the streaming era, sync rights were relevant to the use of compositions and sound recordings. They're separate sync licenses. If you put a piece of music into a movie, you have to license both the composition and the master recording. Sometimes the master is referred to as a master use license. Sometimes it's called a master sync license. But certainly you need a composition sync in order to do that as well. And so again, there's history there. And there really wasn't that much sync activity until the early 70s, when American Graffiti and a variety of movies came out that started playing nostalgia music from the 50s as a way of selling the movies. And since then, there's pretty much a 20-year lag time between the period that's been covered in movies and culture because of the audience that they're trying to get. And so typically music is used to bring the audience back to the mood of a particular time. Publishers can also promote songs. Now, managing and enforcing song copyrights, one of the big elements is, and this ties into some of the questions that we'll talk about later in terms of collaboration, is infringements. And that is that people use or just simply copy other people's songs without permission. Publishers can be the party, if they own the copyrights, who bring infringement suits to prevent that from happening. In most cases, and you have to forgive me because I'm a career lackey for the record companies, and I'll disclose that right up front. I always have viewed copyright infringement cases as a way of basically protecting the rights of people that create content. And so I basically viewed myself as being in the business of making sure that creative types get paid what they're supposed to be paid. But as with everything else, they have been abused through the history of music. And there are hundreds, if not probably thousands, of pretty frivolous music copyright cases that have been brought over the years. I did a music copyright case in the 90s for Janet Jackson, and one of her songwriters, Jimmy Jam, who's in the Songwriter Hall of Fame, was deposed. And they asked him, have you ever been sued for copyright infringement before? And he said, yes. And they asked him how often? And he said, how many #1 songs do I have? So like a lot of things in our wonderful society, people view claims like that as a lottery ticket. And so the courts are filled with not only meritorious claims, but far more frivolous ones. And publishers also collect and distribute royalties. Let's move on to the next slide. And what do the PROs do? You know, I think we've talked about all of those. I guess we didn't talk about the second element. There are various rates that are paid for the uses of music. And there are very specialized tribunals that set rates for mechanical royalties, for performance right royalties. And my firm is really the firm that does those sorts of cases. I personally have not, but they're run out of our Washington, D.C. office. And they set the standard rates that apply to various uses of music. The PROs, when they collect performance right money, when they collect it, they distribute it to their songwriters. They also have support for songwriters, professional support that's there, particularly to startup songwriters. You'd be surprised at the amount of information that's available through BMI and ASCAP as starting places. And I think I made one of those websites available for people to look at as a starting point if they have other questions. Next slide, please. Okay, and we talked about this, and that's part of the problem of ad-libbing, is that you jump ahead and say the things that are going to be on subsequent slides. But HFA is the Harry Fox agency, and as I said, it represents the publishers in issuing mechanical licenses for the making of phonorecords and for for other types of recorded uses. And it represents digital services in obtaining mechanical licenses. The MLC is yet to be formed, but it will be formed shortly, and it's going to collect and distribute these digital mechanical royalties. Next slide, please. Okay, now we're shifting briefly from the composer to the performer, and now we're dealing with the sound recording copyright. And so there are artists, the name artists, and also lots of other people that are featured there. Sometimes the songwriters are performers as well. There are producers, there are record companies, and there's Sound Exchange, which collects digital funds for all of this. One of the things that is sometimes an issue is who owns the rights in a sound recording. Typically, that is decided by contract. so that everybody that's involved in the creation of a sound recording agrees and divides up interests in a recording contract before anything is recorded, sometimes afterwards. But lots of other times it's done after the fact, and sometimes there's a fight over things, a fight over who owns what, particularly in the hip hop world, and more recently in the more collaborative forms of music, where there are so many contributors that it's not really clear who owns the shares. And those issues are rarely litigated to trial, but they can lead to a bunch of squawks. Do producers have interests in the creation of sound recordings? Do engineers have interests? I mean, the term producer, as most of you know, is a very flexible term. I've actually received producer credit on a number of jazz records that I worked on, and to say that I produced them is generous. I worked in terms of the project, and sometimes the producer credit is given to people who own the company and do nothing on it. So those are the major players in the recording side. We can move on to the next slide. And what do record companies do? Now, this is probably what I know best, because I've done more work on the record company side than anything else. And sometimes when I'm involved in record company lawsuits against websites and ISPs that don't pay for the use of music, I have to go through this entire litany of just look how wonderful record companies are and all the different things that they do. They find artists, they do A&R, they produce the records, they clear the songs, they make the records, they distribute the records, blah, blah, blah. They get the copyrights for the records, they issue licenses, they distribute royalties, and all of these things are absolutely true. All of these things happen. But I think many of these have been affected more by the digital age than by compositions, because people can create recordings now in their living rooms and without the benefit of record companies. And there are ways of getting recordings out to the public that don't require the infrastructure of record companies. And as a result, record companies have shrunk. And there's a good debate that could be had as to whether that's good or bad for society. I think what happens now is that, this is my own editorial opinion, is that what does come out of the record companies is much more homogenized. There's much less willingness to take risk on new music because there is a lower margin. A lot of people are doing things on their own, and record companies want to deal with more sure bets and less investment. So let's move on to the next one. Okay, well, this is Sound Exchange is a client of Jenner and Block, and we do a bunch of work for them. And they are the ones that collect performance money for the digital exploitation of sound recordings. There are licenses and direct deals. As I mentioned, is the Copyright Review Board, rate board that shows that I don't do that work. Down in DC, and those proceedings go on every couple of years and are very intense, heavily litigated disputes where different interests like the streaming sites and the radio stations and various others talk about how outrageous the amount of money that they have to pay to the recording artists are, and that goes back and forth, and there's lots of expert testimony, etc. Let's move on to the next. And this unfortunately is the biggest casualty of 2020, which is, as all of you know, artists have been devastated by the absence of live performance, and frankly, audiences and fans like me have been devastated, but more emotionally than financially, because we can't hear the things that are our greatest inspiration and pleasure. But there are companies like Live Nation and AEG and others that promote big tours, but there are thousands of smaller promoters and venues all over the countries that are now looking for other ways of getting content out and staying alive. And National Sawdust is obviously one of them. And even before COVID and even before 2020, The part of the reason I got involved with National Sawdust was to get involved in strategic discussions about how do we get artists and performances done at National Sawdust out to greater audiences. And we were talking about the power and possibility of streaming before it became a mandatory fact of life over the last 6 to 9 months. Next slide, please. And what do promoters do? This is what promoters do. I don't, you know, I've been rambling on so much that I don't want to cut into time of the question and answers by talking about it, but it's pretty obvious what promoters do. They book it and they advertise it and they run the shows. Next slide, please. And the next slide is the last slide. So there we go. We've run through the basics. There's a lot more there than what we've had the time to cover, but the purpose of this really was to get to a few more pressing concerns, and Paola and I think basically view this as giving the building blocks from which we could move on from there to the more pressing issues that may be of interest to all of you, but hopefully that presentation was of some interest too.
I have to tell you, I wish I had, you know, this kind of guide, you know, guiding and understanding when I graduated. So I think it is very useful, very useful. And, you know, before we go to our two composers who have questions, I was wondering, Andy, if we could talk a little bit about some of the questions that we're getting at National Sawdust, and then I'm you know, asking other composers asking me, and so I've written a few, and I'm going to start with, how have music publisher rights and fees changed during this increase in the live streams?
Well, probably the biggest issue that we're going to talk about, Paola, is streaming and sync licensing. You know, I think that comes up in a lot of different contexts. One of the things that's happened during the pandemic, obviously, is that there is no performance money really being paid. And so everybody feels that. Artists feel that, venues feel that, and publishers feel that. One of the ways, but publishers have more weapons at their disposal, economic weapons at their disposal, than the other parties that I mentioned. And so one of the ways that they can look to try and recoup some of their losses is by being more aggressive on the rights that they try to pursue. And that you see that with regard to live streams. Clearly there is a need to get a performance license for a live stream, and most venues have that. But the question really becomes, do you need a sync license as well? And if you remember at the beginning, I was saying a sync license requires the synchronized use of music in timed relation to a video image. A concert satisfies that, a movie satisfies that. When you have a visual image and the music is married to it, that is debatably a sync usage. However, if it is just being performed, if there's no recording that's been made, you don't need a sync license. That really is the law.
So are you saying that you'd essentially be asking for almost like two types of royalties?
Yes.
Okay, that's interesting. Huh.
Yes. And so what the publishers are doing now, because the real challenge here is when you do a live stream, there's always some recording. Now, the easiest cases are when a venue performs a work, adds it to their archive, and people can access it when they want, for money or not for money.
Right.
That clearly, in my opinion, requires a sync license. Okay, so if a publisher said you have to pay a sync license, you have made a recording of an audiovisual performance, and that, like the use of music in a movie, requires a sync license. And unlike other types of licenses like mechanical licenses and performance licenses, that's granted by the publisher and negotiated each time.
But what if a composer is self-published? How do we, and where do composers go to understand, you know, what these rates are?
Well, with regard to the performance monies, a composer really needs to be registered with one of the performing rights societies. And then the Performing Rights Society grants licenses to National Sawdust, to lots of other venues, collects the money, and they have formula for how they pay the money. They typically get set lists, and they go through the actual process of finding the composers and passing the money through back to them. But, so the performance side of this is relatively straightforward. The real issue comes on the sync side, because, as I said, the rates for performance licenses and the rates for mechanical licenses don't vary much. The mechanical licenses don't vary at all. The performance rights license typically varies by the size of the venue, and there are formulas within each of the performing rights societies to decide that. But sync licenses are granted at the grace of the publisher. They don't have to grant it at all, right? So, and if you create a sync use and if you don't have a license, you could be sued for copyright infringement. So that is where the rubber meets the road on a lot of these issues. And the big question becomes, therefore, is there a recording? Do you need a sync license? And it hasn't been fully litigated out. The courts haven't really decided how much recording. Let me back up a minute. So if you're streaming a piece, typically it goes into the cache memory of the computer of everybody that's watching. Now, I'm not that technically competent, but I can get you that far. There was a decision that basically the Cablevision decision in the Second Circuit, which is where we reside in the federal courts, that said that when there was a buffering and a recording that lagged like for a second and a half behind, and basically it then performed, that wasn't a recording. It was not a recording that required a sync license. So, and that case dealt with network DVRs. It was Cablevision. But, the question becomes, where along the lines of recordings do the recordings at issue fall? So the easiest case, as I said before, is if there is a recording made, it's kept in posterity, people can access it later. That is a sync use. You need a license. End of story.
Right.
But a lot of these are really short-term recordings that disappear. And whether or not you need a sync license really is a kind of a gray area in the law. And so publishers can be aggressive because, well, it's like suing Google, right? Litigation is a poker game where each side knows how many chips the other side has. Right. And so if the publishers go after Paula for, a copyright violation for not having a sync license, you're going to be going, how do I get out of this lawsuit? Because I can't afford, all of the costs of going through the court system, and there's no upside to me. And so they actually exploit their economic power to try and get more payments presumably for their composers, but obviously for themselves as well. So there's this giant gray area in the middle of live streaming that depends upon the types of recordings that are made of the performances to try and determine whether or not there is a recording that requires a sync license.
Right. It's fascinating, and I have a bunch more questions, but I think more important, I want to get to these two composers because this is their time. So I'm going to tell you a little bit about who's going to be next.
Okay.
The first question is going to come from James Diaz. He is writing for the National Sawdust Ensemble. And he is a Colombian composer and sound maker and composes music that strives to create unique sonic textures, sound masses, and interactive environments. He's currently a doctoral candidate in composition at the University of Pennsylvania as a Benjamin Franklin Fellow, and he's the co-founder of the Colombian Composers Collective C3. James, why don't you join? Oh, you're here. Hi. Excellent. Welcome and go for it.
Hi, Paola. Hi, Andy.
Hi, James.
Thank you, Andy, for such a detailed presentation. Thank you so much. So I guess that my question is more about the concept of fair use, because it seems that is also something that is, around this gray area now, especially for, everything that is digital now. So, and like, for example, we have so many music YouTubers that kind of use some recordings, because they got blocked or demonetized, right? Or for instance, there are so many people that use sampling as a technique, and now they cannot use some recording for the same reason, or they got, like a sue or something like that. So I wonder what would be your advice, or if there are any, regulation for the concept of fair use.
Yes, that's a terrific question, and one that copyright lawyers talk about all the time. And I think, to a large extent, it depends on what your lens is on the music industry. I think that traditionally, if you're talking about pop music as opposed to other types of music, the music that you write, the music that's played at National Sawdust, there was pretty much consensus as it started happening that if you actually use a sound recording that's the commercial sound recording to create your new work, that is a derivative work. Okay, so one of the building blocks of copyright law is in Section 106 of the Copyright Act. There are certain exclusive rights that are given to the copyright owner. Okay, one of them is the right to duplicate it, to publicly perform it, to distribute it. But another one is to create derivative works. So if you take a recording and you make it the core of your recording, debatably, and I think a good argument would be that you need to license that. And if you're trying to create a real commercial recording, like if you're doing a major label release, obviously there's sampling in all of those recordings, and they have big staffs that actually go out and license all of the samples, and that sample clearing process is very intricate and it's very important because you want to make sure that you don't get sued. The issue becomes much more challenging when you're dealing with less commercial and more artistic, smaller distribution types of music, where the use of a sample may be a very just a limited sound, or it may be something that is a building block, just like a musical phrase, as opposed to being a big identifiable musical element of the song. I did a copyright case for Jay-Z in LA in 2015, and it related to a song of his from 2001 called Big Pimpin'. Not, whatever. I won't make any comments about Big Pimpin', but the song is just what you would think it is. And throughout the song, there's a sample of a piece of Egyptian music, and there was a license for it. And frankly, there needed to be, because it was a loop. Granted, it was only 4 or 5 seconds, but it played throughout the whole song, and it was the identifiable persona of the song. And it was a commercial song and the rest. It becomes much more difficult when you're dealing with other types of works where there are smaller samples and where the sample is almost just a musical device as opposed to an identifiable taking of something that existed before. And so the rules on fair use are very, very general. There are 6 statutory factors that are set forth, and you have to look at whether it's going to impact the market of the original work and a variety, the amount of the taking it, is it for commercial purposes, and a variety of other things. And in the last 10 or 15 years, there's been a little bit of a judicial revolution on that subject. And now most courts, led by, again, the court here, the federal court here in New York, look primarily at the issue of, is the use transformative? Have you taken something that was one type of animal and made it into a different type of animal? So there's a different nature of expression. Fair use can also deal with, is it a parody or is it commenting on a pre-existing work? But, I don't personally like the transformative use test because it's a label and it means whatever you want it to mean. I mean, one of the most significant cases is not in the music world, but it's in the art world, and is a case called Prince versus Carriou. And Richard Prince is a very famous mock-up type of artist. And Carriou lived with Rastas in Jamaica and took pictures of them and made albums and, very creative works. Prince took those photographs, superimposed electric guitars, drew mustaches on them, did all sorts of things and sold them for hundreds of thousands of dollars. And the court said that was a transformative use because they're competing in different marketplaces and it changes the nature of it. I disagreed with that about as much as you can disagree with it. I think that basically he took this person's work, made it the basis for his own. I mean, you look at it, you cannot avoid thinking this was somebody else's work, and didn't pay for it. So this is such a wide open gray area. I do understand the issue of people being demonetized on YouTube, and that's a challenging issue too. I mean, YouTube started out as the biggest engine of copyright infringement that had ever been seen in the Western world, right? It started off without any licenses, without any permission, just knowingly broadcasting copyrighted content and playing music and not paying anybody for it, and got so big and got so much money behind them. And then started implementing some devices to try and immunize themselves from copyright infringement. And this monetization program is a way that they approached many of the studios and recording companies who they had ripped off for billions of dollars, and are trying to give pennies back to them. I mean, really, when you get down to it, when I talked to you before about the digital revolution, there was such a transfer of wealth from the creative world, from the world of composers and record companies and the creative side, to the technical platforms. All of these platforms, they don't create music, but they've co-opted it and made most people think that the music is a commodity and what they're paying for is the technology that transmits it. I think that's horrible. I think it's horrible that we pay the technical platforms and the composers and the artists get minimized in the process. But that's one of the things that's happened through, people, particularly people several generations below me, younger than me, look at this and say, music should be free and the record companies are thieves. And, there's an element of truth in all of these statements. But what has happened is that the amount of money that went to the creative side of the ledger has diminished, and the amount of money that's gone to the technological distribution platform side of it overwhelms it. Right now, YouTube, and obviously its parent Google or Spotify, could buy all of the record companies with their petty cash, funds. So there are a lot of issues that are going on here. I think for a start out composer, there are a lot of challenges. Oh, one last thing I really should mention, which is that educational uses do have greater fair use coverage. So if you can demonstrate, put aside the monetization issue on YouTube for a minute and just deal with, could you be sued for, playing music in a streamed class or something like, if it's really an educational process, there's a lot more protection. I mean, as I said, I'm typically on the content side, but I have a case that I'm doing right now for Princeton University where they're being sued for use of copyrighted material that they used in education for researching machine vision. And so there is absolutely a fair use defense that we're mounting based upon the type of use. Not-for-profit use has a greater fair use protection than commercial use. But these are great issues that we could talk about for hours. And thank you for raising the question. I don't know if I gave you any clarity or to just shine a light on how confusing the area is, but thanks for raising it.
No, thank you, Andy. Thank you so much.
Oh, you're muted, Paula.
I'm so sorry. Can you hear me now?
Yes.
Sorry about that. So we're going to go on to Clifton Joey Guidry III. He is also writing for the National Sawdust Ensemble. And a little bit about him. Radical self-love, compassion, laughter, and the drive to amplify Black art makers and noise makers comprise the core of Clifton's work. He's a bassoonist, a versatile improviser, and the composer of experimental and daring new works that embody a deep love of storytelling. He spearheads the composer competition and commissioning platform Sounds of the African Diaspora. Hi, Clifton. Hey, nice to see you. You're also muted.
Actually, I don't think he is muted. I don't see the mute sign.
Oh, okay.
Hello. Are we?
There we go.
There we go.
So I'm reading a question on the behalf of Julie. So do you see the nature of authorship changing as multiple people are credited with substantial roles in the co-creation of a piece of music? And how can institutional funding and enforcement help create a more collaborative space?
Well, that's also a terrific question. And my answer to the first part is no. I don't think that the nature of authorship is changing because I think that these types of issues have arisen throughout copyright history. I think the first real change in the volume of collaborative work came with hip hop music, where the use of samples and producers and performers, you had so many people engaged in the creative process, and frequently it wasn't documented in terms of who's getting what, and figuring out those shares became very difficult. But the law on ownership is pretty standard. It's basically, was there a mutual intent to create a joint work? And if there's a mutual intent to create a joint work, then all of the people who are contributing to that, if it's an important role, I mean, you can't, if you say, hey, play a note over there, you're not going to be a joint owner of that. But, there have been issues over the decades about people that create different parts of a creative work, and then they are merged together and it's exploited commercially. And is that a joint work, or do each of the people have a copyright in their own separate piece that they're free to exploit without sharing the proceeds with the other party, getting permissions, all those sorts of things? So I think the basic issue of joint ownership has been around for a long time. The nature of collaborative composition and recording has changed, as I said before. I still view that as starting first in the hip hop community, but I think that, I think the world has become more collaborative. We had our annual partner meeting at my firm today, and the whole theme of the meeting was trying to make the firm more collaborative and less eat what you kill. It's no longer about who the 900-pound elephant in the room is. It's now about, how do we work collaboratively to get the best out of everybody? And I think that whole notion of teamwork and collaboration is wonderful, and one that didn't exist in my time nearly to the degree that it does today, which ties into the second piece of your question, or Julie's question, which is, can institutional funding help create a more collaborative space? And certainly, to the extent that an institution brings various collaborative elements together into that petri dish of creativity and has them work together, it creates the opportunity as part of that setting for them to set rules and to have the people who work together on a project agree to the way that ownership in those properties is going to be divided up. It's very, very difficult if you have private citizens who just come together on a particular creative project and then have a disagreement. Who's going to resolve that, right? I mean, it's just the people fighting with each other. Originally, record companies could play that role because they're the ones that release the record, and they would go to everybody that's involved and say, hey, either you agree on how this is going to be divided up, or we're not going to release it. And it acted as a way of forcing agreement. But an even better way, if you're doing collaborative composition and working together, in that environment, is to have the rules set forth up front. And if you're doing it through an institution that everybody is connected to, that provides an opportunity for doing that in a way that otherwise doesn't exist. Hopefully that provides a little bit of clarity for you and for Julie.
Yeah, thank you.
Sure.
Very cool. All right. Thanks, Clifton. So Andy, I think, I have more questions, but I think we're reaching the end of our time. And I feel like if I go down another rabbit hole, we could be here another hour together, which would be fun.
It would.
But I can't wait to share live music with you soon, hopefully.
Oh, I can't wait either. Can I make one comment? And this is going to sound so ridiculous, but it's meant comically more than anything else. You guys were so terrific in terms of putting out the little blurb on me in this whole event, and asking about that first concert that I went to and all of the rest of it. And the only thing I want—
Did I get it wrong?
No, the only thing I want the world to know is I would never refer to Franz Schubert as a 19th century songster, which is
I think that was probably changed by our marketing, or maybe some copy that I found, or that
and I mean it in jest. Working with you and working with National Sawdust is such a pleasure, and I told you that endlessly, and I mean it as deeply as I can.
Well, we're grateful, and I know that on behalf of all the composers who you're going to talk to a little bit after on our little post discussion, we're just very grateful. This is a time where a lot of these questions are coming up, and people don't actually know where to go for a lot of these answers. And so to have this time with you has been invaluable.
Well, can I say one more thing?
Yeah, absolutely.
If any of the composers have, I can't promise. I don't have encyclopedic knowledge, and so I provided certain resources. But if there are really issues that people have that are immediate and pressing and they want to pass it on to you, I'd be happy to hear from them and provide whatever help we can.
Thank you. And you should make sure to check their concerts out in December, because the new music being written is really, I'm excited to hear it. So hopefully you'll tune in. All right. Thank you so much. Take care, Andy, until soon.
Bye.